Okay, the court is on the record in City of Conneaut versus Daniel J. Erler, case number 26 CRB 47. This case is set today for a initial appearance hearing on a charge filed against Mr. Erler.
Right from the start, something interesting stands out. Mr. Erler is appearing in court without a lawyer. Even for a small charge, that can be risky. The legal system moves fast, and one wrong decision here could change the outcome of the entire case.
He is present without counsel. Mr. Erler, a complaint has been filed against you. Have you received a copy of that complaint?
Yes.
Okay, I'm going to read you your rights, so please pay attention to the rights I'm about to read to you. You do have a right to be informed of and to understand the nature and the elements of the charge filed against you. You also have a right to know the potential penalties that could be imposed. You are charged with one count of junk and unlicensed vehicles. That is a fourth-degree misdemeanor. If convicted of this offense, you face a maximum of 30 days in jail and a maximum...
Now, at first glance, this might sound like a minor issue, just a junk or unlicensed vehicle. But legally, it's still a misdemeanor that could even carry jail time. That's why the judge is carefully explaining every single right before the case moves forward.
Fine of $250 plus court costs. Do you understand the maximum potential penalties you face if convicted of this offense?
Yeah.
Okay. You have a right to remain silent and not to say anything during this hearing that might incriminate yourself. Any statement you make could be used against you. You also have a right to a trial to the court. And because you are charged with an offense that carries a possible jail sentence, you also have a right to a jury trial, provided that you timely file with the court a written demand for a jury trial. At trial, you have the right to confront and ask questions of any witness who would testify against you. You also have a right to use the court process to secure the attendance of any witness who you would want to testify on your behalf. At trial, you have the right to be proven guilty beyond a reasonable doubt and a right not to testify. You also have a right to have an attorney represent you in your case, and because you are charged with an offense that carries a possible jail sentence, you do have a right to court-appointed counsel and to have a lawyer assigned to represent you only if you cannot afford one. If you do qualify for court-appointed counsel, there is a $25 application fee and a $50 cost reimbursement assessment that apply. You also have a right to a continuance of this initial appearance hearing in order to retain the services of your own attorney or to consult with your own lawyer at your own expense. If you are convicted of this offense or any related offense, you have a right to appeal the conviction or sentence. That must be done within 30 days of the conviction, and you would be entitled to a court-appointed attorney in the Court of Appeals if you receive a jail sentence and cannot afford a lawyer. Now, if you plead not guilty today to this charge, I will set your case for further proceedings after today, and I will set a bond. A bond is set by the court to ensure your appearance at all future proceedings, and today you have a right to a reasonable bond. If you are not a citizen of the United States, you're hereby advised that conviction of the offense to which you could be pleading guilty or no contest may have the consequences of deportation, exclusion from admission to the United States, or denial of naturalization pursuant to the laws of the United States. Now, Mr. Erler, you have three plea options that are available to you with respect to this charge. You can either plead guilty, not guilty, or no contest. If you plead guilty, that is a complete admission by you to the offense charged. If you plead guilty, the court will find you guilty and then I will impose sentence. The second option is you can plead not guilty. If you plead not guilty, that is a denial by you to the offense charged. And as I said earlier, if you plead not guilty, I will set your case for further proceedings after today and I will set a bond. The third option is you can plead no contest. If you plead no contest, that is not an admission of your guilt, but it is an admission by you of the truth of the facts alleged in the complaint filed against you. If you enter a plea of no contest, this court will find you guilty and I will impose sentence, without any evidence being presented against you. However, the plea of no contest cannot be used against you in any later civil or criminal proceedings. Okay, Mr. Erler, do you have any questions regarding the rights or plea options I've just explained?
No.
Okay. So with respect to this charge of junk and unlicensed vehicles, a fourth-degree misdemeanor, how do you plead?
And there it is, the no contest plea. This is where many viewers get confused. It's not exactly the same as pleading guilty. Instead, the defendant accepts the facts in the complaint without admitting guilt directly, which allows the judge to decide the case without a trial.
No contest.
Okay. Do you understand by pleading no contest, Mr. Erler, that you are waiving your right to a trial, which includes your right to cross-examine witnesses and to confront evidence presented against you? You'd be waiving your right to testify or not to testify without any negative connotation. You'd be waiving your right to subpoena witnesses. You'd be waiving your right to a jury trial. You'd be waiving your right to be proven guilty beyond a reasonable doubt. All of those are trial rights you'd be waiving by pleading no contest to this charge. Is that what you wish to do?
Yes.
Also, by pleading no contest, you would be waiving your right to an attorney. You do have a right to have an attorney represent and advise you in this case, but by pleading no contest, you would be effectively waiving your right to an attorney. Is that what you wish to do?
Yes.
Are you currently under the influence of any drugs, alcohol, or prescription medications that might affect your thinking?
Nothing.
Okay. Are you currently on probation, parole, community control, or post-release control with any court?
No.
Has anyone made any promises to you about what your sentence will be in order to induce you to plead guilt or no contest to this charge today?
No.
And are you thinking clearly and do you understand everything that's happening?
Yes.
Okay. In order for the court to be able to accept any no contest plea, because no contest pleas are unique, the law requires me to obtain an explanation of circumstances. And so that explanation can either come from you or from a report the court has in its file. But the law director submitted a written bond recommendation, and on that bond form he indicated that on January 20th, 2026, the defendant failed to comply with the junk vehicle notice served upon him on January 6, 2026, regarding a camper located at 355 Jefferson Street. Do you find that explanation acceptable?
Not a junk vehicle.
Okay.
I didn't have a plate on it.
Okay.
Which I do have a
Well,
plate
in
on.
your own words, tell me what this is about.
There was no there was no plate on the camper, and it wasn't covered, so he basically had sent me a notice saying it was a junk vehicle.
Now the real story starts to come out. According to Mr. Erler, the camper wasn't junk at all. It simply didn't have a license plate at the time. Situations like this are surprisingly common in municipal courts, where city code violations can quickly turn into criminal charges.
And I actually corrected that.
Okay.
I have a plate on it now.
Okay, so you received notice, this says you received notice on January 6th, and as of January 20th, it had not been
Well,
taken
we
care
did
of?
have quite a bit of snow, and I was not able to move it
Okay,
or do anything with it.
okay. But that is the case though?
Yes,
Notice on January 6th, it was still there on January 20th?
yes.
Okay, I do accept the explanation of circumstances, I do. Okay, well, there is a document I need you to view and sign first. Do you read and write English?
Yes.
Okay,
That's
Okay, I'm gonna-
handwriting, but
that's all right. I totally understand that. Okay, I'm going to give you a document that's entitled Acknowledgement of Rights and Waiver of Counsel. Take a look at that. If you have any questions regarding it, feel free to ask me. If you find it after reviewing it acceptable, you can sign in date at the bottom. Okay, the court finds that Mr. Erler has executed in open court the written acknowledgement of rights and waiver of counsel document. I do find that the defendant's no contest plea is knowing, voluntary, and intelligent. The court will accept a no contest plea to this charge, and I will therefore find him guilty of junk and unlicensed vehicles. Okay, Mr. Erler, in cases like this, I normally defer sentencing because I would like the law director to be present to tell me that the situation has been rectified. You kind of alluded to the fact that you've moved the trailer?
No, I haven't moved the trailer. I actually got plates for it.
Oh, yeah.
But I am looking at selling it.
Okay. Okay, so here's what I'm going to do.
And here's the twist in this case. The judge isn't sentencing him today. Instead, the court wants proof that the issue has actually been fixed. In many city ordinance cases like this, showing the problem is resolved can sometimes make a big difference in the final outcome.
I'm going to defer sentencing. You can tell the prosecutor isn't here today. The prosecutors are never here on Tuesday mornings for initial appearance hearings. So I'm going to defer sentencing. We're going to have you come back in a couple weeks or so when the prosecutor is present. Because I would like you guys to talk, and before I impose a sentence, I would like to know the status of the situation, at least from the city standpoint.
Okay.
Okay? So you can continue to bring in whatever paperwork you brought today, but I'll defer sentencing for 2 weeks. You are living at 355, 348 Madison Street?
Yeah.
Okay. Okay, I'll set bond in the amount of $1,500 personal recognizance. That you don't have to pay anything today. What that means is we're going to give you a date and time for your next hearing. If by chance you failed to come to that hearing or any future hearings that we're going to give you notice of today, I could impose a warrant, and I could order you to pay $1,500 to the city as a penalty for failing to come to court. You understand that?
Yes.
Okay, so when you leave the courtroom, you're going to make a right, go to the clerk's window, and they'll take care of you, okay?
Okay.
Okay, do you have any questions?
No.
Okay, sir. Thank you very much. You have a good day now.
Thank you.